Most people read Supreme Court cases wrong. Even law school students do this. So today I'm going to show you how you can read a Supreme Court opinion. This is the exact same method that helped me rank in the top 10% of my law school, and I promise you, you don't need a law degree to follow along. Now I'm also going to link the case in the description below, and it's free to access, free to read for yourself if you want to do that after the video. But before we get into looking at one of my favorite cases in all of law school about the ability of the police to spy on you in your home with thermal imaging or all sorts of futuristic technologies, I want to start by telling you what it is you should be doing when you read a case. Now, before you start reading a case, you need to first shift your mindset, okay? You're not reading this case for information, you're reading this case for arguments and ideas. 3 of them to be exact. You're looking for the argument of one side is going to tell you why they should win, the other side is going to tell you why they should win, and then the Supreme Court is the 3rd argument. They're going to weigh in and they're going to say who they agree with and why. And it's not always the same reasoning that was offered to them by one party. So that's what you're looking for. It's not about the information. It's not about reading every word. It's about understanding the arguments. A good way to do this is to start by asking yourself, what are we even talking about? And that would be in reference to the facts that actually led up to these arguments. What are they premised upon and around? The other thing you want to ask yourself is, what does either side want to get out of this? And lastly, you should try to think about, why does the Supreme Court care? They chose to take this case on. They didn't have to. Why did they do that? And once you've shifted your mindset into looking for the answers to these questions, you're then ready to start reading the case. But what does that look like? So step 1 of reading any case is the facts section, okay? So let's get immersed in what happened, and you're going to want to ask, what is interesting about this case? What is invoking the thoughts about fairness here? When you found that, you have found the issue of the case. And most of the time, we can honestly ignore the procedural stuff. That's just a fancy way of saying what happened in the lower courts, the district court and the appellate court, before it came to the Supreme Court. But once you've identified the issue for the case that you're reading, make sure you break it down into a real question. So for example, in the case that we're going to look at today, you would not want to state the issue or question as being one of, is this a violation of the 4th Amendment? If you were to do that, your notes in a 4th Amendment criminal procedure class would all be the same when it came to the issue section. You want something more tangible, more common, more simple. Can the government use futuristic technologies to look into your home without a warrant? The next step is you're going to want to read this opinion from the Supreme Court's perspective. I always like to look for, what is the court afraid of getting wrong here? What are the ramifications? Another helpful thing in any area of law you're entering into is, what are the precedents that the court is protecting, relying upon, or departing from? Now, a quick note before we move on dissents, okay? If you have time, dissents are great to read. They're usually saying something really interesting, which is what is justifying them to go against the majority in the first place. But at the end of the day, you do have to remember, these are the losers. They didn't get their way. What they said is not the law. And really, I just like to read the dissents for catharsis when I disagreed with the majority or think that they got it wrong. Once you finish reading the case, you want to translate its holding into real life. Think about, what can the police do tomorrow because of this decision? Or what is it that they cannot do anymore? And who is the winner long term, the people or the government, especially in the criminal procedure context? Now, with all of that being said, let's go ahead and take a look at an example, one of my favorite cases from all of law school, and that would be Kyllo versus United States from 2001. Again, this case is linked in the description if you want to go through it with me or after at your own pace. Okay, so I've worked a lot with this case over my time in law school. I read about it in criminal procedure, and there was 2 different moot court competitions where this case was a big deal, and we had to know the ins and outs of it. But for the purposes of today's video, I didn't want to have to go and dig up all my old notes, so I went ahead and I just used Mid-Pages AI, and you can see that there on the right. So first things first, let's go ahead and get into the facts. In order to determine whether an amount of heat was emanating from petitioner's home consistent with the use of such lamps, that being grow lamps for a marijuana grow operation, 2 agents used thermal imaging scanners to inspect a triplex. The scan of Kyllo's home took only a few minutes and was performed from the passenger seat of Agent Elliott's vehicle across the street from the front of the house and also from the street in the back of the house. The scan showed that the roof over the garage and a side wall of petitioner's home were relatively hot compared to the rest of the home and substantially warmer than neighboring homes in the triplex. Agent Elliott concluded that petitioner was using halide lights to grow marijuana. Essentially, we have a case where the cops are looking for someone who is growing marijuana. Can they use this futuristic, at the time, this is 2001, futuristic technology to look into a home or get an idea of what's going on inside of the home? Now here, we need to start thinking about what seems weird about this case. What is interesting? Well, that sounds like a violation of privacy. I don't want officers inspecting the home, even if it is from outside, with these sense-enhancing technologies. That seems really strange, and they're using it to get an idea of what I'm doing inside the comfort of my home. We also need to consider, why did the Supreme Court take this case? Well, thermal imaging scanners is at the time a new technology, but its use is something that is coming up more and more. And if the Supreme Court doesn't address it, it will continue to be used. So that's why the Supreme Court is taking this, to protect the Fourth Amendment and make sure it is not being violated. Now, I told you at the top of the video, this is not about information. We don't read cases for information. We read them for the arguments and for the ideas. And when we understand which ideas are better than others in the eyes of the Supreme Court, we understand better what the law is and what the Constitution says. So let's go ahead and take a look at the government's argument here. The government maintains, however, that thermal imaging must be upheld because it detected only heat radiating from the external surface of the house. This wasn't anything going on inside the house. This was heat coming outside the house. Here, the court is going to reject that. They're going to reject it because they've already had cases where they struck down similar ideas. They talk about the Katz case, where eavesdropping devices picked up only sound waves that reached the exterior of a phone booth. Reversing that approach would leave the homeowner at the mercy of advancing technology, including imaging technology that could discern all human activity in the home. While the technology used in the present case was relatively crude, the rule we must adopt must take account of more sophisticated systems that are already in use or in development. What is coming down the line as technology gets more and more sophisticated? And that's what this case is really about. And here we can see another argument that the government raises, and we can also see how it is that the Supreme Court refutes it. So above, we saw the precedent where they looked at their Katz case. That was, again, eavesdropping on a phone booth. And they were able to say just because sound waves are measurable outside of the phone booth does not give you the right to eavesdrop and ultimately gather what is happening inside the phone booth, especially where there's an expectation of privacy. And if you know anything about the Fourth Amendment, you know that one of the biggest parts about it is the home. One of the biggest things it's most interested in protecting is the home. So let's look at the second argument that the government raised and the Supreme Court ultimately refuted. The government also contends that thermal imaging was constitutional because it did not detect private activities occurring in private areas. It points out that in Dow Chemical, that would be a past case, a previous case of the Supreme Court, we observed that the enhanced aerial photography did not reveal any, quote, intimate details. Dow Chemical, however, involved enhanced aerial photography of an industrial complex, which does not share the Fourth Amendment's sanctity of the home. The Fourth Amendment's protection of the home has never been tied to measurements of the quality or quantity of information obtained. It's about the home, full stop. So now I want to end our look at this case by what is the rule overall, and that's going to help us determine the takeaway. What is going to happen going forward? How is this going to affect police power, my privacy in the home, and all these other concerns that we might have? And it's going to give us an idea of what is the current law in the direction that it's heading in. We think that obtaining by sense-enhancing technology any information regarding the interior of the home that could not otherwise have been obtained without physical intrusion into a constitutionally protected area constitutes a search, at least where, as here, the technology in question is not in general public use. This assures preservation of that degree of privacy against government that existed when the Fourth Amendment was adopted. So what we're seeing here is that they have laid out the rule, they've struck this down, but there's a little caveat if you caught it. At least whereas here, the technology in question is not in general public use. So they leave the door open for things to change. This is about novel, cutting-edge, futuristic technologies, but once something becomes commonplace in everybody's use, standard practice, well then the door is open for things to change. So let's end on what are the takeaways. Well, we know that in the future, new cutting edge technologies are not going to be permissible to investigate inside of my home. But things might be different if it is no longer a rarity. So that was how I actually read cases. And I hope that it was insightful. And if you want me to do another one, go ahead and leave a comment below. And don't forget to check the description if you want to read the case for yourself and all the parts that I left out, especially the dissent. And again, as always, I hope you have a really good rest of your day. Take care.